Thank you. All right, and I'm going to call next the default judgment on New York Life Insurance versus Gonzalez and Ubale.
Yes, Your Honor. Tracy Campbell.
All right. And so let me the default is only against one of the two defendants, correct?
Yes, Your Honor. We provided the citation to both defendants as noted in the motion, and we just received return of service that she no longer is at that address, and we attempted to identify additional addresses for her and also noted that she's not a service member, so we have been unable to find her since then after actually serving her with the original petition, and she failed to answer. And notice of service is included as an exhibit, exhibit A in our motion for default.
Okay. So the problem that I have, Ms. Campbell, is your notice of hearing. It's in my file, and it indicates that these motions are set today at 9 a.m. in front of Judge Lori Iserlo. So just because the case is filed in the 455th doesn't mean your hearing is in the 455th. In fact, it's in the 200th. And so we have a central docket here in Travis County. This notice is defective. There's no way basically, I think you need to reset. We have a form on our website that has the proper notice, the way to give notice when we have a central docket and the way our cases are assigned, but I don't think we can proceed today given what is on file.
Okay, Your Honor, so I can
Yeah, so contact the court administrator, get a new hearing date, and then look at the district court's website. There's a tab for forms, and there are some form hearing notices, both in person and remote, but they have, you do not want to say which court or which judge it's going to be in front of when you send the notice, because you have no idea. It could be one of 12 judges, so. All right.
Okay, so that's for both motion, the motion.
Yeah, you can do one notice, but you just need to reset them. They can be the same date and time. Just the notice needs to indicate it'll be set on the central docket, and there's some other language we have. So it gives the parties who receive the notice an opportunity to actually appear and contact court admin to get the Zoom link if it's going to be remote, or, how to find where the proceeding is.
Okay.
But, I mean, your notice doesn't, it does say it will be by Zoom, and that's good, but it says it's in front of Judge Iserlo, and it's just defective on its face, so I'm not going to proceed based on it.
Okay.
All right. You're excused from the virtual remaining.
Thank you.
Case, I believe, on the motion to dismiss the 91A Penn Hall. And is everybody left here for that case?
Yes, Your Honor.
Okay. All right. We'll go on the record then in Penn Hall versus Archer Western et al. You may make your announcements for the record.
Your Honor, Brett Sanders for the movants in this particular case, which is Archer Western, DBA Great Hills Constructors.
Good morning, Your Honor. Kyle Hawes and Vincent Bryan on behalf of Penn Hall Company.
All right, and Mr. Sanders, it's your motion, I believe. I'll just say this was added late by the court admin. So normally I would have read the motion and the response. Unfortunately, I did not have that opportunity. So you may proceed with that understanding.
Thank you, Your Honor. I will walk you through. This is a 91A motion to dismiss, so it's a procedural issue. In my mind, it's a pretty simple issue, but the issue is whether my client was properly named in the suit to begin with, whether the defendant is entitled to the relief it seeks, which is dismissal, and whether we're also entitled to our attorney fees. This case arises out of work performed by a subcontractor, Penhall, for my client, Great Hills Constructors, on the 183 A North project in North Austin. The facts of the case, the underlying facts of the case and the allegations in the underlying case are irrelevant for purposes of this motion because, again, it's a procedural motion. So I'm not going to bother the court with that, just rather the procedural happenings in this particular case. So Great Hills Constructors is a paper entity, Your Honor. It's an assumed name entity, as pointed out in our motion. It is a joint venture between two joint venture partners, Archer Western, which is out of Chicago, and Sunt Construction, which is out of Arizona. And so there is an assumed name certificate that's been filed in both Travis and Williamson County, as the court would expect, to do work on this particular roadway, 183. But plaintiffs, when they filed their petition, first amended petition on June the 4th, 2024, they identified Archer Western as a DBA, Great Hills Constructors, and that was improperly named. And interestingly enough, in plaintiff's first amended petition on page 4, Exhibit C, there is a letter that they have imposed on that pleading, which specifically says on there that Great Hills Constructors is a joint venture. They didn't plead it that way. Instead, the way they pled it was Archer Western DBA Great Hills Constructors. That's an improper party. But the reason I bring that up in plaintiff's first amended petition, Judge, is because plaintiffs can't come in here and deny the fact that it knew that Great Hills Construction was a joint venture, because even though they didn't plead it that way, it was imposed on their petition on page 4 as a letter of intent, basically to contract. So in July, I spoke with Amber Ali, who is an associate at Mr. Hawes' firm. Mr. Hawes is lead counsel. I think he's got Vincent Bryan here today, who's also an attorney with their firm. I do not believe that Amber Ali is still with their firm at this particular point, in fairness to Mr. Hawes and to Mr. Bryant. But in July, I spoke with her and advised her that I'm going to be filing, you sued the wrong party. I'm going to be filing a motion to dismiss. I really don't want to my client doesn't want to expend the fees. So please, run the traps and see if you can get this dismissed without me having to file this motion. I gave her over a week. There was no response. I then called her back around the Wednesday preceding, well, it was July the 30th specifically, to see if she was going to be dismissing the case. She advised, we're going to be amending our pleading tomorrow. I waited to see if there was going to be an amendment. There was none. So I had received no call back and no amendment. And as the court knows, there's a limited amount of time in which a defendant has to file a motion to dismiss. So I drafted my motion because it's time limited. Plaintiff thereafter, I did receive some correspondence after we filed our motion saying, hey, we're going to amend. That was in early August. Plaintiff didn't file their second amended petition until September the 5th, which was last Thursday, Judge. So when they amended, here's the important thing, when they amended, which the court can take judicial notice of the pleadings in this particular case, but when they amended, they added Archer Western and Sunt doing business as Great Hills Constructors. And I think that under the rules, they could have done it. They could have pled it a couple of different ways. But the important thing, which that's correct, Archer Western is a 60% partner, Sunt's a 40% partner, and there's an assumed name certificate as Great Hills Constructors. But they left in the petition the incorrect parties. They left in Archer Western DBA Great Hills Constructors, which I verified in an answer that it was incorrect. And they also added in Sunt individually, and Sunt individually is not a correct party because it's not doing business as Great Hills Constructors either. So that's an improper party. So plaintiff didn't dismiss the incorrect parties even after we filed our verified denial, our verified answer saying it was incorrectly named. And they added another incorrect party, which was Sunt individually. The correct responsible party pursuant to Texas case law is the joint venture. And there is a case that's pretty on point, and we've listed it in our motion. It is Corinth Joint Venture versus Lomas and Nettleton Financial Corp. It's 667 Southwest 2nd, 593 at 595. 593 is the case. So that case is on point. My client should not have been forced to file this particular motion, and by amending its petition a second time and adding, which something now that partially corrects the issue, plaintiff judicially admitted that defendant was correct, even though it still has incorrect parties named. So we're entitled to dismissal. Defendants are entitled to the relief it requested of Archer Western, DBA, Great Hills Constructors. We're also entitled, Sunt should never be a party. My client wants the attorney fees that it has expended to this particular point, and which I've calculated at $4,092.50. And if I can share, I'll just show an Exhibit A that we've uploaded, and I'll show you my chicken scratch.
I think that exhibits are supposed to be numbered, not lettered. But
Okay, my apology.
I'll let my court reporter talk to you about that offline.
Okay, we can rename this Exhibit 1, but if the court will, so on August the 1st, I've billed the time that it took me to draft this motion, and I've excluded the amended answer, the verified. If I was being difficult, I would also ask them for my amended answer, but my fees for but I excluded that. So that's how you get $38.67.50 for the motion minus the $130. So that comes up to $37.67.50. And then 1 hour for this particular hearing, which is another I'm billing my time at $3.25 an hour. So it comes to $4,092.50, Judge, for the time that I've spent on this. So I will stop sharing that now. And Your Honor, I can go through in more detail, but that's my motion. And again, I'm asking the court to grant this relief on behalf of my client. Thank you.
Okay. And did you want to offer the exhibit into evidence?
Yes, Your Honor. And whether the court wants to mark it as Exhibit 1 or Exhibit, let's just list that as Exhibit 1.
Okay. Mr. Hawes, any objection to the exhibit?
No, Your Honor.
Okay, it's admitted then. And I think you may proceed.
Your Honor, if I may share my screen.
You may.
I am hopeful that the court can, I may have just cut it off again. I'm sorry.
It was there. Okay, here we have it.
Your Honor, I think that this is the silver bullet that kills this werewolf. This is the Texas Business Organizations Code, section 152.305. An action may be brought against a partnership and any or all of the partners in the same action or in separate actions. This is the Texas Business Organizations Code governing general partnerships, effective January 1st, 2006. As counsel just recited on the record, Great Hills Constructors is a partnership with two partners, one of which is Archer Western, his client, that has filed this motion. The other partner is Sunt Construction, the other partner to the partnership. Under this provision, our client was within its rights statutorily to bring an action against one of the partners, both of the partners, and the partnership. We have amended our petition a week ago on September 5th to name both partners and the partnership. So our position is the motion should be denied on this basis alone. Secondly, the amended petition that we filed on September 5th, 2024 names both of the partners. Penhall has named Sunt Construction. It is also named Archer Western. Point number 4, when the defendant entered its initial appearance in this case, it filed an answer on behalf of Great Hills Constructors on July 1st of 2024, and I'll stop sharing. July 1st of 2024, it entered its initial appearance as Great Hills Constructors, improperly named as Archer Western Construction, LLC, DBA, Great Hills Constructors. Now, why is that important? That pleading got superseded and amended on or about August 1st, 2024, but the defendant did not name who the entity was that Mr. Sanders represents in that second amended answer that had a verified denial. Point number 5 is, on or about August 1st, 2024, the initial mandatory disclosures of Archer Western Construction, the defendant, were due. We never got them. Why is that important? Because as the court knows, in mandatory disclosures, the defendants are required to provide the correct names of the parties to the lawsuit, the name and address of any potential parties, and under 194.2b, a copy of the document or documents that would support its claims or defenses. We got none of that because no disclosures have ever been served in this case by Mr. Sanders' client. Point 6, this motion is procedurally defective. If they felt that this was an improperly named party or partnership or unincorporated association, they can take advantage of Rule 28 of the Texas Rules of Civil Procedure, which allows a party to file a motion to substitute the true names of the parties. But I believe under the Business and Organizations Code that I previously cited, we are well within our rights legally and factually to bring these parties into this case. Point number 7. There is an assumed name certificate out there in this that has been filed with the Texas Secretary of State's office. And I'm going to find the actual exhibit. On March 4th, 2022, Archer Western Construction, LLC filed an assumed name certificate with the Texas Secretary of State's office in its name, doing business as Great Hills Constructors. This is attached as Exhibit D to our second amended petition, which was filed a week ago. The movement has neither withdrawn nor amended its motion to dismiss under Rule 91A. But this document, which was placed of record by Mr. Sanders' client, clearly enunciates and states that Archer Western Construction, LLC is doing business as the assumed name of Great Hills Constructors as of March 4th, 2022. This is also in our response to the motion to dismiss. Finally, Your Honor, I looked again before we filed our response, or strike that. Mr. Bryan looked a week before we filed our response and our amended petition on September 5th. We couldn't find an entity called Great Hills Constructors as an entity. 2 days ago, someone filed an application, a gentleman named Gary Geppert filed an application for registration under the name of Great Hills Construction or Great Hills Constructors, a foreign limited partnership 2 days ago on September 10th of 2024, naming that as a foreign limited partnership with two general partners, Archer Western Construction and Sunt. Now, I didn't file that in my response. I just looked this morning to verify what we saw a week ago, but 2 days ago, someone placed that of record with the Texas Secretary of State's office. My client is definitely concerned by this motion. in light of the Texas Business and Organizations Code, there is both a basis in law and in fact that this petition was legally and factually and legally based under the law. We can bring in joint venture partners, and we're asking the court to deny this motion on that basis. And we're also asking that as the prevailing party, we be awarded our attorney's fees under 91A7, and we can submit an application to the court after that, Your Honor. But based on the law and based on the assumed name certificate and based on the fact that when we filed the petition, there was no other entity other than Archer Western LLC doing business as Great Hills Constructors, we believe that there was both a basis in law and in fact. And because we have not ever received the disclosures of the defendant, Archer Western, we did amend out of an abundance of caution to name Sunt, Archer Western as general partners. And we've also named them in the quote unquote joint venture that was listed on page 3 of the movement's motion. So, Your Honor, for all of those reasons, we're asking the court to deny this motion and award Penhall Company its fees and costs. Thank you.
Okay, Mr. Sanders, your motion, so you have the final say.
Thank you, Your Honor. Very much appreciate it. I have first of all, the partnership provision that was shown to you by Mr. Hawes, 152.305. It says that suit can be filed against a partnership. And that's the operative language, and any or all of the partners. So they didn't sue the partnership, Your Honor, and that's the important thing. And they didn't sue the joint venture partnership originally either. So that's the key distinction. Secondly, Your Honor, I want to show the court an exhibit. I'm going to mark this as Exhibit 2 for purposes of this proceeding. Can the court see this record?
I can.
This is the assumed name certificate that was filed. Entity name, it says Archer Western and Sunt Construction, General Partnership. And the period of duration, 10 years, names them both, filed on May the 26th, 2021. It's for only the following counties: Travis County, Williamson County, and it's signed by the managing partner. There it is, Your Honor. Now, I want to talk about, that's Exhibit 2, and I'm requesting the court receive that particular document.
All right, and Mr. Hawes, is there any objection to Exhibit 2? Oh, you're on mute.
Yes, Your Honor, there is an objection because we've never seen that document before. I cannot find any location that it's ever been filed of record in any counties or jurisdictions or the Texas Secretary of State. So we object to it as being extrinsic evidence.
All right, Mr. Sanders, what's your response?
Yeah, it's rebuttal based upon what he's indicated to the court, Your Honor. And it's to clarify that my client actually did file a document with the Secretary of State and with specifically listing business being done in these particular counties only. So I'm asking the court receive this document.
Okay, I'll overrule the objection. The exhibit submitted.
Your Honor, with respect to disclosures, I want to address that because I think it's important. When I spoke to Amber Ali originally, she asked if they could have additional time for their disclosures. I said, no problem. You don't need to file it. Let's get this issue regarding the parties worked out first. She indicated that we didn't have to file our disclosures either. And so I understand what Mr. Hawes's concern is and representations to the court, and we will certainly get our disclosures on file. But I wanted to make that clear to the court that that conversation took place, and that's what the conversation was. And I realize that Mr. Hawes was not a party to that, nor Mr. Bryan in this particular case. But again, Your Honor, I just wanted to point out that the case law says that the joint venture partnership needs to be sued, and it wasn't sued in this particular case. And again, we're asking for our attorney fees, and I'll leave it at that.
Okay. All right, council, I'm gonna need to take this under advisement so I can review what you put in front of me. I understand the issues. I don't think I have any questions for you. Looks like this is a fairly recent case, so you tell me if you have anything coming up that requires a ruling immediately, other than the requirements under 91A, which the court is subject to.
Yeah, Your Honor, I think this is just briefly, I think that I know the motion has to be heard. I think it has to be ruled upon within a certain amount of time, and I think that time is tomorrow. I think it expires tomorrow.
All right, lovely. Well, we'll do our best. I appreciate it. Thank you, counsel, for your time and for your patience. You're excused from the virtual courtroom. Just
Thank you, Your
need
Honor.
patience this afternoon. All right, Mr. Deere,
Yes, Your Honor.
you may proceed.
Thank you very much, Your Honor. Just kind of give you about a 1-minute roadmap on this one. Mr. Gonzalez is before the court, having entered into an agreement with my client, CBC Settlement Funding, seeking to sell a portion of a structured settlement that he's receiving as a result of, unfortunately, the wrongful death of his mother. Mr. Gonzalez owns and operates basically an automotive repair shop there in the Austin area. Mr. Gonzalez, when he recently changed locations, had a person who he believed was going to be a business partner. That person was supposed to put up a security deposit on the new location. And very recently, after being in operation for a number of months, Mr. Gonzalez realized and was informed that that security deposit wasn't paid, and basically was given a very quick option of, you need to come up with the money or otherwise we're kicking you out. He was able to make some arrangements essentially to hold over to this hearing, Your Honor, but in this particular transaction, he's seeking to sell 2 lump sum payments, one of $25,000 due in October of 2026 and one of $37,500 due in October of 31, selling a total amount of $62,500 in exchange for an immediate payment of $28,000. And primarily he's planning on using these funds to kind of get caught up on all the things he's gotten behind on due to this unfortunate circumstance in his business. He will have remaining portions of the structured settlement. I think he's got about $220,000 that he's not selling, that's still coming down the road, another lump sum payment. So I just wanted to give you that quick roadmap if I can offer his testimony briefly.
Okay.
Right.
Mr. Gonzalez, if you would put yourself off mute. Raise your right hand. Do you swear or affirm the testimony you will give in this cause will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Go ahead, counsel.
Thank you very much, Your Honor. Mr. Gonzalez, can you please state your name for the court?
Ryan Gonzalez.
And Mr. Gonzalez, you reside in Travis County, Texas, is that correct?
Yes, sir.
And how old are you, sir?
I am 32 years old.
And are you currently married?
No, sir.
And do you have any minor children?
I have 2.
And Mr. Gonzalez, it's my understanding that you operate your own automotive repair shop, is that correct?
Yes, sir.
And Mr. Gonzalez, you're before the court this afternoon, having entered into an agreement with my client, CBC Settlement Funding, seeking to sell a portion of a structured settlement that you received, unfortunately, as a result of the wrongful death of your mother. Is that correct?
Yes, sir.
Very sorry for your loss, sir. In this particular transaction, you have entered into an agreement to sell 2 lump sum payments from that structured settlement, specifically a lump sum payment of $25,000 due in October of 2026, as well as a lump sum payment of $37,500 due in October of 31. Is that correct?
Yes, sir.
And you understand, Mr. Gonzalez, that you are selling a total amount of $62,500 if you were to add those payments together.
Yes, sir. That is correct.
And in exchange for those payments, you have agreed to receive an immediate payment of $28,000. Is that correct?
Yes, sir.
Now, Mr. Gonzalez, we had a brief opportunity to visit in preparation for this hearing. And it's my understanding that these funds are essentially going to be utilized to kind of financially recover from an incident where a person who was planning on being a business partner essentially did not make a payment for a security deposit at your current location. Is that correct?
Yes, sir.
And you indicated to me that the owner of the property where you're currently operating your business informed you after you'd already been there a while that that security deposit was not made, and as a result, that he applied rental payments that you have made to that security deposit, which then required you to scramble to essentially make up the difference. Is that correct?
Yes, sir. That is correct.
Okay. And it's my understanding that you still owe back rental payments on that property, which is the primary focus of this transaction. Is that correct?
Yes, sir.
Okay. And you had made arrangements with your landlord essentially to kind of forego any eviction on your business pending this transaction so that you could have the time to raise the funds necessary to get caught up. Is that correct?
Yes, sir. Mike at I guess CBC had when I talked to him about it, he sent a letter out that gave a kind of brief summary of what was going on, and I provided that to the landlord. So he's been kind of impatiently waiting for this.
And Mr. Gonzalez, you also mentioned there was a couple of other items that you personally got behind on, just as kind of you scrambled to kind of deal with this situation that you'd like to get caught up on as well. Is that correct?
Yes.
Now, Mr. Gonzalez, while I had a brief opportunity to visit with you regarding this transaction for background information purposes, you do understand, obviously, I'm not your attorney. I can't give you any kind of, any legal or financial advice regarding this transaction. Is that correct?
Yes, sir. I understood that.
Okay. And my client at the onset of this transaction did advise you in writing that you do have the right to go speak to an attorney or a financial advisor. It's my understanding that you did speak to, I believe, one of your customers who is in finance regarding this transaction. Is that correct?
Yes, sir. I spoke to the same attorney that helped me with the first one, as well as speaking with some of the other gentlemen that are financial advisors.
Okay. But Mr. Gonzalez, you do understand that if you did want more time to visit with them any further, or just to think about this transaction any further, you obviously could have that time. That we're certainly not here to pressure you to complete this transaction today. Do you understand that?
Yes, sir. That was made clear to me. I actually took about a week or so with the original inquiry to kind of digest this and go over that with them before moving forward and signing any paperwork.
And Mr. Gonzalez, you indicated to me yesterday that you did essentially explore all your potential options, and this is this way that you decided to kind of deal with this unfortunate situation. Is that correct?
Yes, sir.
Yeah. And Mr. Gonzalez, just so the court is aware, you're not selling the entirety of your structured settlement. It's my understanding that you'll still be entitled to receive a lump sum payment of $37,500 due in October of 2031, a lump sum payment of $100,000 due in October of 2036, and then an additional lump sum payment of $84,016 due in October of 2041. So you still have about $200,000 plus that you're holding on to that's not part of this transaction. Is that correct?
Yes, sir.
Now, Mr. Gonzalez, just in wrapping up, sir, are you absolutely certain that this is what you want to do in the way that you want to kind of address this unfortunate circumstance you found yourself in?
Yes, sir. I believe this is my best course of action.
And do you believe that this transaction will be in your best interest, sir?
Yes, sir.
And are you asking the court to approve the transaction?
Yes, sir.
Your Honor, that's all I have unless you have any questions of us.
I may have a few questions for Mr. Gonzalez. So let me just ask you, have you discussed this sale with an attorney of your own?
Yes. The attorney that I worked with on the original transaction that I did was the same one that I talked to about this and had him review it as well. I originally made the inquiry. I got the paperwork from CBC, and I took that information, discussed it with the attorney as well as a couple other people that are in finance before calling and trying to finalize this.
Okay. Have you spoken with a CPA about this proposal?
My CPA is the one that I normally discuss this stuff with as well.
And you discussed it with him?
Her, yes.
Her, okay. Have you transferred or sold any prior payments?
I sold half of one when COVID hit.
Okay. And do you know what the effective discount rate is on this transaction?
We did the math. I don't remember the exact number off the top of my head. I think it was somewhere around 49% or something like that.
And Your Honor, I do have that calculation from me, just to kind of clarify things. The nominal rate on this transaction is 17.9. The effective is 18.5. The shorter, smaller deals are always a little higher, unfortunately. But that's what the rates are of this particular transaction.
Okay, thank you for that.
Of course.
Okay, well, Mr. Gonzalez, I'm sorry to meet you under these circumstances, at least what resulted in this structure. Sorry for your loss. And as far as this proposed sale, I am going to appoint an attorney ad litem to review the proposed transaction. I will enter an order doing so. This person will represent you. You understand Mr. Deere represents CBC.
Yes,
So
ma'am.
this person will be appointed by the court. They will review this and discuss it with you. And if you still intend to go forward, the matter will simply need to be reset so that a judge can look at it after that has been completed. Do you have any questions?
So I will be appointed another attorney?
An attorney ad litem. Mr.
Okay.
Deere, would your office be able to prepare that order?
Certainly, Your Honor. And before we get necessarily to that step, just because I don't think I've had this circumstance when I've had someone who's actually consulted their own attorney, have an attorney appointed for them after they've been through that. Are your concerns regarding the transaction just financial in nature, or if it's I might be able to contact my client if it's just a financial concern, just because I know Mr. Gonzalez does, he's kind of at a rock and a hard point. So I do want to, if we can help him today, I'd like to do that. We can certainly go through that process of having an attorney ad litem, but given that they're holding this, his landlord's basically holding it pending this transaction, I just want to make sure he doesn't get in a more precarious spot if that's what it is. If it's a matter of you want us to sweeten the pot, I can certainly try to get my client to do so if that's where your concerns are.
Well, so he's appeared here in court pro se, and so I don't really have any knowledge other than what each of you have told me, which
Right.
is insufficient for me to comfortably sign off on this.
Certainly, Your Honor.
So it is very typical to appoint an attorney ad litem to review these proposed sales. I mean, taking $28,000 today for what would amount to over $60,000 in the future, that's needs to be given further consideration. I'm not capable of being the one to I'm not the financial planner. I just need to have much more information before I would approve anything that with those terms.
Certainly, Your Honor. Well, we can certainly prepare that order, and I will. Would you like me to email that to your staff?
Yes, please. And we have a wheel, so we will appoint the next person up on the wheel to serve as attorney ad litem. And Mr. Gonzalez, you'll be notified of that, and that person will be in touch with you to review and discuss this transaction. And then if you still want to get it approved, then it just merely needs to be reset, and it can be reset on the central docket. It doesn't have to necessarily come back to me. It'll be quicker just to reset it.
Absolutely, Your Honor. We'll get that order to you here shortly.
Okay. All right. Y'all are excused from the virtual courtroom.
Thank you.
Thank you. And we are on the record, so you may proceed, Ms. Inman.
Thank you, Your Honor. Just to give you a little bit of background and some numbers that I think you might want to need just before we get started and before I ask Mr. Masick some questions. So specifically, we are asking the court to approve a transfer of structured settlement similar to the hearing that you just heard a moment ago. In this particular deal, Mr. Masick would be giving up his annual payments of $8,235.50 beginning September 29th, 2024. through September 29th, 2047. Those are guaranteed payments. And he would also be giving up annual payments in the amount of $8,235.50 beginning September 29th, 2048 through September 29th, 2071. These are life contingent payments, which is a fact that's pretty important for the evaluation of this because Mr. Masick is not guaranteed to get those payments. Certainly, we hope that he lives a very long life, but those payments don't start for, another 24 years. And in the event that anything happens to Mr. Masick, our client would be out that money. So that factors into their calculation and coming up with a present day value. And so when they adjust for the consideration of mortality and do their underwriting, the present day value adjusted for mortality is $275,530.58. In exchange for this, he would get $103,800. The effective interest rate that is applied is 9.4%, and he would be getting 66.11% of the present value. And generally, Mr. Masick, he is in school right now, and so he is hoping to get the money immediately so that he doesn't have to work nearly as much, so that he could fund his school and have that money to live off of rather than wait for it later. And I'm happy to proceed with asking him the questions now.
Okay, that's I must have missed it if you said what this was the result of.
The original settlement.
Yes.
I do not recall. I want to say it was an injury, but I don't actually recall. Mr. Masick, would you be able to tell?
I'm gonna
Yes.
swear him in first. Okay. Mr.
Okay.
Masick, good afternoon. Raise your right hand. Do you swear or affirm the testimony you will give in this cause will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, go ahead, Ms. Sinman.
All right. Could you please state your name for the record?
Yes, my name is Nicholas Raymond Masick.
And Mr. Masick, you understand that we're here today to ask the court to approve a transfer of structured settlement agreement that you've entered into with Wilcox, correct?
Yes, that's correct.
All right. And you understand that I am not your attorney, but I'm Wilcox's attorney, correct?
Yes, correct.
So under this agreement, you heard me tell the court that you would be giving up your annual payments of $8,235.50 annually from September 29th, 2024 to September 29th, 2047. And also your life contingent payments in the amount of $8,235 beginning on September 29th, 2048 through September 29th, 2071. And in exchange, you would get $103,800, correct?
That's correct.
Okay. This would not be all of the money that you receive under your current annuity, would it?
No, it's not.
Okay, so you would still be receiving, do you know how much you would be receiving in payments?
Yes, I believe the amount after selling those payments, I will be getting $5,000 yearly, and that will move on to throughout the years. Through 2048, I'll get $5,000 a year instead of $8,000 a year, and that will move forward into the future.
So originally, when you entered into this agreement or the underlying settlement agreement, what happened that allowed you to get this recovery?
So originally, when I first began getting these settlement payments, I had received a paper from Wilcox stating that there was a way that I could sell some of my future annuity payments in order to get funds immediately. And I was very interested in this because I actually only get one yearly payment. And I figure that this will be very much more helpful to me if I can get it faster, you know?
And so I think my question wasn't very clear. So when you originally, what happened that allowed, what injury was it that you're getting paid for? Like all of this settlement?
Oh, okay. Yes, it was a lawsuit with the hospital from when I was born. I was not injured personally, but I was part of the lawsuit. It was a bunch of premature babies, and the nurse didn't wash her hands. She was not sanitized, and the hospital ended up hiding it, the truth of it, until I was about 4 years old, of which they had contacted my father, and I was entered. Yeah, I was part of the settlement in that case, but I wasn't affected by it. But there was babies that have, special needs. They are their deformation. It was very, very bad.
Right. So to your knowledge, you don't have any ongoing issue as a result of the underlying issue.
No, ma'am. No, ma'am. I'm healthy and I'm smart.
Okay. And so what is it that you want to use the money for?
So I want to use the money that I'm getting from selling this future payments. I'm going to be getting, I think it was $1,300 a month. And that will be for the next 5 or 6 years. I will get those payments monthly, and that right there is going to help me extraordinarily when it comes to being able to pay my rent, and I'm not short on rent, while I'm going to college.
Okay. And so do you understand that if you waited and didn't enter into this agreement, you would get more money in the long term by waiting?
Yes, I do understand that, and I've gone over that, and I think that this is the best decision for myself right now at this point.
Okay. Do you believe it's in your best interest to enter into this agreement? Oh,
Did he freeze? Mr. Masick, are you still there?
I think we lost him.
Oh, no. Yep, it looks like he has frozen. I don't know if you want to try and call him, Miss Inman.
Sure. Let me mute myself. I'll call him right now.
Okay, I'll give you a couple minutes and we might have to move on. We'll see.
Did not answer, but I suspect he's probably going to try to get right back on if he can.
There he is.
Oh, there.
Yes. Hello.
Mr. Masick.
Hey, I'm so sorry about that. My phone overheated.
Oh, okay. Well, Miss Inman, you might want to try to quickly go through your
Sure.
remaining questions.
And I just have a couple points of clarification that I want to make sure that we make clear
Okay.
to the court about the deal. So first, you were talking about 1,200 and something monthly payments. So the way that the lump sum payments will come, or the earlier payments, I called it a lump sum, but I want to correct to the court. You get a $30,000 lump sum almost immediately after the court signs the order, and then you start getting monthly payments in the amount of $1,230. Is that your understanding?
Yes, that is my understanding.
Okay, and so that's what you were talking about with respect to the monthly payments.
Yes, yes. How much that's gonna help me? It's extraordinary for me. It's absolutely of my best interest.
Okay. Mr. Masick, you cut out. We missed most of what you just said.
Hold on a sec. Hello?
We can hear you now.
Okay, great.
Okay, and my understanding, and please correct me if this is not your understanding, but you would have remaining payments in the amount of guaranteed annual payments for $5,000 annually starting 9/29/24 through 9/29/47. And then you would also have remaining life contingent annual payments of $5,000 from 9/29/48 through 9/29/71. And then also you have life contingent annual payments of $54,691.97 with a 3% cost of living increase every year starting in 9/29/72 and continuing for life. Those would be your remaining payments after the agreement, correct?
Yes, that's correct.
Okay. All right. And do you want the court to approve the agreement today?
Yes, I do.
Okay. I pass the witness, Your Honor.
All right. Mr. Masick, let me ask you just a few questions. Have you transferred or sold any of these payments previously?
Yes, Judge, I have.
Okay. And how much did you receive in the prior sales?
In the prior sale that I I received $48,000.
Was it just one prior sale?
Yes, ma'am.
And when was that?
This was about a half a year ago, maybe a little bit more, 8 months ago.
Okay. And how did you come to be connected with Wilcac Life Insurance?
Well, I originally I get my life insurance payments from Wilcac Life Insurance, and I had received a notice in the mail that told me that it was possible for me to restructure my settlement payments, and then of which I became in contact with him. But I've been in contact with him for a couple of years now since I've been getting the payments. I originally had a trust fund set in place, so I didn't personally deal with Wilcac Life Insurance, but I've been dealing with them for about 2 years now.
Okay. And do you know what the discount rate is of this proposed sale?
Yes, I believe the discounted rate it would be 66%, I believe.
Okay. Have you discussed this proposal with an attorney of your own?
No, Your
Okay.
Honor, I haven't.
Have you discussed this proposal with a CPA or a financial planner?
This I have. I discussed it with my at my bank with my banker, but I don't know if you would call that a financial advisor.
Okay.
But he certainly did have a look at it.
All right. And you're in school right now. What are you in school for?
Yes, ma'am. I'm in technical school.
Okay.
I go for welding.
Okay. Did you complete high school?
Yes, ma'am. I graduated from Leander High School in 2016, which of course was a long time ago now. But my original plan was to go to college. And the older that I'm getting now, the more that I'm realizing that would have been the best decision to have made. And that's my plan now. Is I'm ready to go ahead and go to college. This is gonna help me to pay my rent every month. This is gonna help me to go to school and focus on school primarily. I'm going to technical school right now, welding, to learn a welding trade. But it's only once a week or twice a week that I go, so I'll have plenty enough time to go to college. I'm gonna start off at Austin Community College, ACC, and then hopefully, and after that, eventually, I'm gonna go to University of Texas.
That sounds like a good plan. Well, you may have heard my conversation with the prior gentleman, and I'm going to do the same thing in this situation. I am going to appoint an attorney ad litem. That is someone who is going to look at this proposal on your behalf.
Okay.
Help you evaluate it. Ms. Inman works for Wilcac, and I think I would like to do that, take that next step. After that's been reviewed by you and the attorney ad litem, if you still want to proceed, this can just be reset and you can come back to court and just proceed at that time if you still want to proceed.
Okay.
Ms.
Yeah, no,
Inman?
I see all of that. I watched the whole thing, and I was kind of surprised that you did that to him. But this is a timely manner for me. How long do you think it would be until I can get this court date reset?
I do not know, but we'll sign the order today appointing the ad litem.
Okay, that's great. Thank you very much, Judge.
Okay. Ms. Inman, if you would prepare that order and send it to my staff, Mr. Woodby, we'll get it taken care of. We'll use the wheel and appoint the next attorney ad litem up.
Thank you. I do have one quick question. So when we reset it, it normally just goes to the docket and gets assigned randomly. Will this also get assigned randomly, or will it come back to you?
It does not need to come back to me. It'll be quicker for you to get a hearing if you just set it on the central docket. There's no reason to try to get it back on my calendar. That might cause delay, and I don't want to do that. These hearings are usually pretty short. So
if I could, Your Honor.
Okay.
Okay. So when I have my guardian ad litem assigned,
attorney ad litem,
will that help to convince you that this is in the best of my interest next time in court?
Well, I may or may not be the judge presiding over it. The attorney ad litem will satisfy the court on one thing, at least, that both parties have the equity of having a lawyer on their side.
Okay.
The lawyer may tell you this is not a good deal. They may suggest changes. They may say it's a great deal. I don't know. But I do know that you are not on an even playing field, representing yourself with a lawyer on the other side. And this is a very significant financial transaction. You're talking about taking $103,000 for what would be nearly 300,000. So I think it deserves more consideration. I won't approve it as is. So the attorney ad litem is a required step if you want to get it approved. Okay.
Thank you.
Thank you, Your
Okay.
Honor.
Thank you. Y'all are excused from the virtual forum. So we have Schoenberger versus State Farm.
Yes, Your Honor. Robert
And
Disk.
y'all did not need a record, is that right?
May we get a record on this one, Your Honor, if you don't mind me changing?
Yeah, you can. I got to tell you, I'm going to have some questions about this, but let me get our court reporter. Miss Simon, can you hop back on or let us know you're there? Okay. We're on the line, Schoenberger versus State Farm. Counsel, state your appearances.
Yes, Your Honor. Robert Disk for the Schoenbergers.
Luke Dow, guardian ad litem.
Okay. So I've read the motion, and I guess let me just go ahead and give you some questions, Mr. Disk.
Yes, Your Honor.
So 2.5 years ago, a final judgment was entered in this case. So what ability do I have to do anything 2.5 years after the fact?
No, that is a fair question, Your Honor. I imagine your the court's plenary power expired a while ago. I will be frank and say this is the first time I've run into this situation where there's been a final judgment with a contingent payment, and Medicaid comes along and says that does not work for them. I was hoping the court would be able to open it up, reopen the settlement. If not, do we need to file a new action, Your Honor?
Well, here's the thing. So I'm not going to tell you how to practice law or how to do what needs to be done, but let me tell you a few things I did notice. So the motion to modify that you filed, you filed this motion in the old case, and the defense lawyers are on the certificate, the e-service, but it did not go through to any of them. So we're sitting here in court on a hearing in which only one party and the guardian ad litem have notice of. If you'll look at page 4 on the motion to modify, which is the e-service proof, it shows error, 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 error for the 4 defense lawyers. So, and then you have a notice of hearing that indicates only Mr. Dow received notice. So I don't know that, I don't know. I think that's a problem to have a hearing in which a party from the plain review of the case file was not actually notified of this hearing. So that's one issue. The jurisdiction is, I think, problematic. I'm happy to offer you a breakout room if you and Mr. Dow want to chat about creative solutions and think about it while we take up one of the other cases. But I would need some kind of indication that I have authority to do something this late in the game.
Okay, that's fair, Your Honor. And I think a breakout room wouldn't even help us at this point.
Okay.
If we need to get defense attorney here to basically waive any jurisdictional issues, I think we probably wouldn't be able to get that in the amount it would be in a breakout room.
Okay. Well, and I don't, whether it could be filed in a separate cause of action without, I presume they already paid their money and they're on their merry way. Maybe they aren't interested in a special needs trust, but just the way it's filed in this case, I think it's problematic for me. Does that make sense?
That does make sense.
Okay. All right. Well, I appreciate what you're trying to do, and I'll leave you to it. I'm sure y'all will come up with a solution to the situation. But I'll go ahead and excuse you if there's nothing else for today.
Nothing further, Your Honor.
Okay. All right. Y'all take care.
Thank you.
Thank you.
Thank you.
Yes, Your Honor. Blake Dietzman.
Okay. You can go ahead and turn your video back on. And I think we have Mr. Blankenship on the phone. Okay. We're on the record until you may state your appearances.
Your Honor, Blake Dietzman. I was representing Robert Blankenship and RBJC.
DJ Seidel representing Jason Caraway.
All right. And Mr. Blankenship, are you still on the phone?
Yes, ma'am. I'm sorry. I just had to unmute myself. I'm here. Yes, ma'am.
Okay. All right. And so, Mr. Dietzman, it's your motion.
Yes, Your Honor. This is my motion to withdraw. Rick Gonzalez in my office and I represented Mr. Blankenship in this matter, and it's somewhat of a companion, or the facts overlapped in a separate case that Mr. Seidel also is representing Caraway's, that was filed here in federal court in San Antonio. We had a motion to withdraw in that case, and the judge signed the order May 29th of this year. And there is no opposition from either Mr. Blankenship or Mr. Seidel.
All right, Mr. Seidel, you want to confirm that on the record?
Confirmed, Your Honor.
Okay, thank you. And Mr. Blankenship, what is your position?
Yes, confirm that. Yes, Your Honor.
Okay, you're agreed to the motion to withdraw.
Yes, Your Honor, I am.
Okay, are you going to be retaining new counsel?
Yes, ma'am.
Okay, do you have that person ready to file an appearance today?
Not today, no, ma'am.
Okay, if not, I'm going to need to include your address, email, and phone number in the order that releases Mr. Dietzman, so that the other folks in the case know how to get a hold of you until the new lawyer appears. Mr.
Okay.
Dietzman, do you
Yes.
have that information already in a proposed order?
We had presented an order, Your Honor, and we can add that additional information to the order and submit that.
Okay. Yes, I think in this day and age, I just prefer to include everything, the email and the phone number, because a mailing address just does not get it done in 2024.
I understand.
That's my feeling. Okay, well, if you'd submit that updated order to my staff, I'll get it filed. The motion to withdraw is granted. Thanks for your patience this afternoon. Some of these hearings that thought they were going to be very short were not as short as they thought. So thanks for persevering.
Thank you.
All right, y'all are excused.
Thank you, Your Honor.
Versus
Have a good
Neptune
day. Thank you.
At all. Go ahead with your appearances.
Greg McAllister for the plaintiff, Zachary Mautis.
Your Honor, Jairus Jordan, appearing on behalf of the Neptune entities today.
And Taylor Yetter, Your Honor, for the defendant, Sprout Foods, Inc.
Okay,
May it please the court.
yes.
Thank you, Your Honor. And you made the right point during the call earlier. Frankly, surprised that we would go have a motion for default judgment after the defendants have appeared. So let me be more specific. There are 3 defendants, Sprout Foods, and there are 2 Neptune entities, Neptune Growth Ventures and Neptune Wellness Solutions. Only Sprout filed an answer. They filed an answer yesterday afternoon. So we, the plaintiff, are not requesting default judgment against defendant Sprout. The Neptune defendants have filed nothing except for general notices of appearance. There's been no briefing responsive. I'm aware the attorney for defendant Neptune entities sent an email to the court today, I think it was. But they had 2 options. They could have filed an answer, just like Sprout, Or they could have filed a motion to quash. If they're claiming today that there was some issue with service, I think that's going to be their argument. Then they could have filed, actually they should have filed, a motion to quash service under Rule 122, Texas Rules of Civil Procedure 122. They had the option to file a motion to quash. They never did. As Your Honor knows better than anybody, such a motion should have been filed 3 days ago under Rule 21. They filed no brief, no affidavit, no kind of evidence in any manner. So because they filed nothing, Your Honor, except this general notice of appearance, they don't have any right to object to the motion for default judgment request with regards to Defendant Neptune Growth Ventures and Defendant Neptune Wellness Solutions. So we request the court enter default judgment against those two defendants.
Okay, who wants to go next? Ms. Jordan?
Yes, Your Honor. We were just retained yesterday, so that accounts for why nothing has been filed. I mean, as soon as we got retained is when we filed our notice of appearance yesterday. My client knew nothing about this lawsuit until an email that it received maybe a week or two ago regarding today's hearing. To this day, both Neptune entities has not been served with the lawsuit. We understand that plaintiff's counsel attempted to effectuate service through the Hague Convention because our client is a Canadian-based company. But yeah, as Mr. McAllister said, it's our position that service was not properly effectuated. Pursuant to the Hague Convention, a request for service must be sent to the Central Authority of Quebec, Canada, is where my client is located, along with a copy of the petition. We don't dispute that opposing counsel complied with this portion of the convention. However, I had sent a copy of the Hague Convention, which I sent to you all in an email. Under Article 5, which is on page 8, I believe, it states that the Central Authority shall itself serve the petition pursuant to Canadian law. After service is complete, the Central Authority must prepare an official certificate form indicating the method, time, and place of service and to whom the documents were delivered to. It's this part that was not done. Under Article 15 of the Hague Convention, which is on page 10, excuse me, service is not effectuated until it's established that the document was served by a method prescribed by Canadian law. Opposing counsel has not provided proof today that our client received service of this matter or that the Central Authority served our client in Canada. The Central Authority of Canada is not a designated agent for service of process under Hague, and they're not an agent of our company. Therefore, service to them is not effective merely because it's delivered to the Central Authority. Instead, service is complete only in receipt of it to my client. So it's our position today that because service was not properly effectuated, my client has not been served, and we request that this motion for default be denied. I mean, that being said, we're not trying to evade service. We really aren't. And we're happy to work with Mr. McAllister and waive service and prepare a response to the petition. But we just need time to look it over, confer with our client in order to draft a proper response.
Okay, Mr. Yetter?
I think Mr. McAllister made it clear that he's not moving forward against us, so I have nothing further to say at this point, Your Honor.
Okay, you didn't want to talk about the Hague Convention or...
It is interesting.
Yes.
I never thought I'd become a pro in the Hague Convention, and so it is.
So, Your Honor, if I may.
Yes.
I think the argument made by Ms. Jordan is simply not an argument for today. If they wanted to seek to quash, they had some issue with service, Rule 122 is crystal clear. If the defendant has an issue with service and they want to quash, then they have every right to do so. This motion for default judgment has been pending for a long time. So the only thing before us is a motion for default judgment. There's no objection. Ms. Jordan said, well, my client did this and my client, affirms this. There's no affidavit. I'm not going to accuse Ms. Jordan of anything, right? She's just here making an argument, but none of that's evidence. And so if they want to file the only thing before you, Judge, is a motion for default judgment. You've got nothing else before you to enter, is that exact order. And so procedurally, it's not confusing. the only thing that's before you is that order to enter. If they, the defendants, the two Neptune defendants, want to file a motion for new trial, that's the procedural mechanism at this point. If there was something, if they knew a week or two ago, which they've already admitted, and still didn't file the motion to quash, which they're just here verbally talking about today, that's not permissible. I mean, the rules are not unclear. And so for anything other than the default judgment to be ordered would be extremely prejudicial to my client, because that's the whole purpose of having the motion for default judgment, is that defendants don't answer, we file a motion for default judgment. If the defendants say they're going to waive service, they could have filed an answer yesterday, today, this morning, even before this hearing. And my hands I would have been handcuffed, preventing me from seeking default judgment against them. They chose to do none of that. So there's nothing else before us today to enter.
Okay. I would just point out, we are more than happy to provide briefing. Like I said, we had been retained as counsel. I was not notified until this lawsuit until yesterday afternoon. So we will provide any briefing that you want, including any affidavits that you find proper in this matter. But again, I was retained as counsel, did not receive notice of this until yesterday.
And I'm not going to fuss with Ms. Jordan. We've all been there as the attorneys, where the clients should have acted weeks ago and done something. So that's certainly not her fault that her client sat on this and should have acted and then didn't, and put Ms. Jordan, in a bad spot. That's not her fault. But my client should not be prejudiced, because we filed this case in May. We sent email, we sent service, we've tried repeated methods of service. Sprout waited until yesterday afternoon to file an answer. So for my client to have to go through all this attorney fees, and we did everything, we followed procedure to get here, and now we have a verbal quash argument that's not proper by any stretch of the imagination in Texas. So again, there's a remedy for Neptune. They can file a motion for new trial after this default judgment is entered. And so I think the proposed order is before you. I think the only change would be for either you would cross out Sprout, or if you needed me to send you a new proposed order taking Sprout out. That's the only change to that proposed order. If you'd like me to talk more about the attorney fees that we've already proved up with affidavits. Again, my client has spent tens of thousands of dollars now, and frankly, and again, Ms. Jordan wasn't waiting in the weeds. She wasn't hiding. She said, it was her client that sat on their hands for weeks and waited and hid in the weeds, and have basically tried at the last minute come up with this surprise. Well, again, they need to follow Texas procedure, just like my client has had to for months.
And I would like to point out that they received notice of the hearing. They received a random email on the hearing, not the petition. To this day, they have not been served.
Okay. All right, let me. All right, a couple of things I just want to mention, since this case is here pending in Travis County, and so the notice of hearing on the default itself, I would use the term defective to describe it. I mean, obviously you're all here and that's fine, but it simply says it's going to take place on September 12th at 2 p.m. and that it will be remote. It does not have our standard language that you can find in the Travis County District Court's forms about how to get to the right place, how to get the Zoom information. It doesn't mention that we have a central docket, so it's kind of vague. It also, I don't know, doesn't appear to have been served on anyone. I guess one person at Neptune Court is on the e-service, but that's it. So I don't know.
I think a notice for default judgment is not required to be served, Your Honor. That was kind of the purpose. I believe that the purpose of the requirement is the defendants didn't answer the case, so the plaintiff is not obligated or prejudiced to have to keep on trying to find these folks. They've already done that. So in Texas, we're not required to serve notice of hearing on default judgment.
Okay, our local rules do require it. So Just be sure you're familiar with those, because I won't go forward typically on hearings if the notice is defective, if the motion for default hasn't been served, which in this case, it didn't look like it had been. But that being said, typically when we have a hearing on a default and everybody shows up, the default is not entered. So I guess have various procedural arguments about motions that aren't actually filed, like a motion to quash. But
if I may, Your Honor, I agree. I agree with you. I've never been to a default judgment hearing where the parties all showed up, because the only way they would all show up is if they filed some kind of motion or they filed their answer, and we all show up and go, oh, well, everyone's filed their answer, let's go home. But here, what else would a plaintiff do? What else is the recourse for a plaintiff in Texas if we show up for the default judgment hearing and one of the defendants, in this case the Neptune entity, says, well, we're just telling you without any affidavit, without any evidence, without any notice, through our attorney, not even a witness, telling you, we got notice of this weeks ago, but we decided not to do anything. Well, the rules in Texas give the plaintiff a remedy. And so for them to not have any kind of requirement, if we walked away today with no order, there's no remedy for me to move forward. Ms. Jordan said, well, we'll work with Mr. McAllister on something. And okay, I don't disbelieve her, but I'm walking away today without any obligation for me to tell my client what happens now, because we use the rules of civil procedure. If they don't answer, so we walk away today with no order, Neptune still would basically say that we don't have to file an answer. We don't have to do anything, because in Texas, we don't have to do anything. We just send a lawyer to say, we didn't know about it until a few weeks ago. We did nothing. We showed up to a hearing. Maybe we'll answer someday. Greg, go start all over with a brand new default judgment and just spin your wheel. So I'm not unsympathetic to, Judge, I understand the point you're making. But we've done exactly what the Texas, what Texas requires. And the defendant gets to walk away today with no obligation at all. I have if we walk away today with no order, I have no idea when defendant Neptune is going to do anything. I'm sure Ms. Jordan is a very good lawyer and ethical and would reach out to me, but she's not obligated to do anything, because they'll think they can do whatever they want in Texas, and this can just string it along for years. We filed this 4 months ago.
May I speak, Your Honor?
yes, go ahead.
My comment was mischaracterized. I said that we would waive service. And if he wants a specific date, again, we're not trying to evade service. We're trying to get this taken care of. And we want to proceed with the lawsuit. So we will agree that we were served today if that sets a deadline for our client to file some type of response to the petition.
Okay. 20 days and the Monday next from today would be October 7th, Mr. McAllister.
Yes, Your Honor.
That's an offer that Ms. Jordan made. I want to give you an opportunity to consider it and respond.
Yes, I would say, Your Honor, if we can enter a rule, if Ms. Jordan, on behalf of the Neptune entities, will agree under Texas Rule of Civil Procedure 11 that the Neptune defendants will enter a general denial in the next 2 weeks. Nothing else, nothing before a general denial. They'll enter the general denial in the next 2 weeks and a full answer with whatever defenses they might have by October 7th. I think that's more than generous by me. I just don't want any gamesmanship. Defendants should not be rewarded by throwing up some other kind of, things up in the air. The only thing they should file is a general denial. They could file one tomorrow. It takes, 20 minutes.
Okay, but she said she was hired yesterday, so.
Fair. So I'm not really exaggerating about tomorrow, but my point is, if in 7 days, the Neptune defendants will file a general denial, they'll file nothing else in the meantime, and they'll have until October 7th to file their full answer. I think that's a very fair proposal from me. And frankly, they're getting off without a default judgment against them today. So that's a gift.
All right. So it sounded like you did not accept the proposal that Ms. Jordan laid out. Here's what I'm going to do. I'm going to take the motion for default under advisement. I'm going to give y'all 1 week to confer and decide whether it's waive service, accept service, answer by X date. I'm going to give y'all until Thursday, September 19th, to let my staff know if y'all reached a resolution. And if not, you know, I can issue a decision on the default, but I see competent counsel who I think in a week can figure out how to handle this better than I can probably impose on you. So,
Your Honor, if I may, to save time, money, and fees, may I make one more Rule 11 proposal?
to counsel?
Yes, of course.
Yes.
Yes.
Yes, go ahead.
Yes. Under Rule 11, I propose that the Neptune defendants file their answer by October 7th, as long as they don't file any other pleadings before then.
I can't agree to that. We can agree to accepting service as of today, but we need to review the file to see if we need to file any other responses on top of a proposed answer. So no, the agreement I would make is that we would accept service as of today and be allotted the normal rules of civil procedure when it comes to issuing a response. And given that we have not been served yet, I think that is a more than reasonable offer. We're not trying to be difficult, Your Honor.
Okay, Mr. McAllister, do you want to talk that over with your client?
We will agree that under Rule 11 that the Neptune defendants both accepted service today, and their answer is due October 7th, 2024.
Okay, I think she said waive. Did you say accept service or waive service? I can't remember.
We'll accept it today.
Okay,
For
great.
the sake of making it clear.
Okay, so that's now on the record, counsel. Seeing that has been accomplished, I guess I'll hold off, or there's no reason for the court to rule on the motion since y'all have reached that Rule 11 agreement. And I do appreciate that. And I apologize to keep you waiting around all afternoon.
You've got a busy docket, Your Honor. Thanks for your hard work.
Yes, I appreciate it. Yes. Good luck to you, and y'all are excused from the virtual courtroom.
Thank you, Your
Thank you, Your
Honor.
Honor.